Do not grab me! Do not grab me! What are you doing? What are you doing?
Need some medical services. Thank you.
I'm representing myself in what? I mean, I'm confused about what's actually going on.
I would ask you to, as part of this sentencing, to grant me 5 minutes in a locked room with this demon.
Defendants representing themselves, family members trying to get their hands on alleged killers and child molesters, attorneys screaming at judges, some even arrested inside the courtroom. We're taking you inside courtrooms across the country where things devolved into chaos. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. We begin in Beaumont, Texas, where a man accused of horrific charges involving child sexual abuse material. He had quite the fall in court in April of 2026. Literally, he passed out.
Need some medical services. Thank you.
Christopher Smith was arrested after a task force reportedly got a tip about apparent child pornography being shared. And police say they got a hold of Smith's account information and allegedly found dozens of photos and videos of children being abused. And according to court documents, he even uploaded photos and videos of himself as well, which reportedly helped police confirm their suspicions. And during an April court hearing, an attorney was trying to get Smith's bond reduced. A judge had set it at $800,000, but as the judge questioned Smith, he started to sway.
Are you married or single?
I'm married.
Sir?
He's married, Judge. Yes.
Okay. Any children? Do you have any children? Oh, okay. Do you cohabitate with your spouse? Are you living with your spouse? He's down.
Well, he went down on his first shot.
Oh, go ahead, Kitty, and that.
Yeah.
On his face.
Emergency medical services.
Radio. Please.
No.
He passed out.
Just relax. Radio.
Can I get up? That's good. I'll get up. Just sit. Just sit on the floor. Sorry, I apologize. You sit right there.
Where's he bleeding from?
His nose.
He keeps his head up.
Hit his face first, Judge. Luckily, he didn't do that, but he hit his face first. So.
Need some medical services. Thank you. Yeah, he's bleeding.
Yes.
From the face wound. All right.
The jury.
Are you ready?
All right, we're in recess on this.
Smith was taken to get treatment for a possibly broken nose. The judge decided not to lower the bond amount, kept it at $800,000. Unclear if Smith was able to cobble together enough to be released, but his case currently ongoing. Next, we're in San Diego, California, where a TikTok star convicted of brutally shooting his estranged wife and her friend couldn't keep his thoughts to himself during his sentencing. Nope. He even got into a screaming match with his former sister-in-law.
What did they do to you? You didn't do anything to you. You know Anna Marie is not gonna go cheat if you didn't cheat first. Sorry, Your Honor, but this feeling is like make me sick.
So let's back up a little bit. 32-year-old Ali Abulabam was a TikTok personality with nearly 1 million followers. Moved with his wife Anna to the West Coast, but the two's relationship reportedly grew toxic with allegations of cheating on both sides. In October of 2021, Anna asked Abulabam to move out of their luxury apartment, so he went to stay at a hotel. But he came back to install a listening app on his young daughter's iPad. And when he later overheard Anna with a male friend, Rayburn Barron, together inside the apartment, Abulabam raced over with a gun, shooting them both multiple times. He called both 911 and his mom, and then picked up his daughter from school. He was stopped and arrested on the side of an interstate. Despite what looked like a happy and loving relationship on social media, during Abulabam's weeks-long double murder trial, his own voice messages revealed just how much he'd grown to hate his wife.
Bro, your little whore girlfriends wish they had a guy like me. They wish they had a guy like me. They don't even have fathers for their kids. Even Julia said, "You're such a good person to my daughter." I am the best man you ever met, and you're the dumbest I ever devoted my life to. You are the dumbest. I wish we never had a kid together because of how stupid you are. You put Julia and her kid before our own daughter. You put Claire. You put everybody. You put that tranny before our own daughter. You put her before your husband. You are so. You are so. Dumb. You're choosing sides with people who don't give two about you. They will not be there for you. Enjoy your little bar boyfriends. Enjoy your little JD Wyman. Enjoy your little exes. Oh, you cunt. You're my woman. I brought you to this. You should kissing my feet. Ungrateful.
And the trial culminated with Ali Abulaban himself taking the stand to try to defend his actions.
My gun was in my hand, and next thing I'm shooting, and I can't stop. I'm just shooting, and I'm even startled. It's like I'm watching it happen. I'm like I'm in the passenger seat of my own body. I can't stop it, and I hear Anna screaming and crying. And I don't even remember shooting Anna. I just remember running back to the front door, and I grabbed the door handle, and then it hit me. I'm like, did that just happen?
The jury found Abulaban guilty on 2 counts of first-degree murder, and his sentencing is where things really went off the rails. His defense team tried to argue that there had been prosecutorial misconduct, so the whole case should be thrown out, and Abulaban wasn't happy with what the prosecutor had to say about that.
The defendant, his response was certainly showing consciousness of guilt. When I asked him, did you ever brag to Mr. Edwards, his response should have just been no. If he really never had a conversation with Brian Edwards or any inmate in jail about the killings, his response would have just been no. That was not his response. He had an outburst. He told me, is this some kind of jail informant that you're asking me about? That shows his guilt in the fact that he knows who made these statements to inmates in jail. And so it's perfectly reasonable for me to ask those questions.
Yeah, you bull.
All right, let me make something clear right now.
I'm sorry, son.
If there is any disturbance,
Just-
you will be put outside, all right? It happens only once, it's happened now, it will not happen again. And that includes you, Mr. Baldwin. Thank you.
The judge denied the motion for a new trial, which meant victim impact statements were next. And that is when the yelling between Abulaban and his former sister-in-law happened. The judge also gave Abulaban a chance to speak, which he took full advantage of.
On that day of October 21st, 2021, I was in the worst physical and mental state of my life. I was sick, suffering from an untreated severe mental illness that was combined with a crippling drug addiction, which put me in a state of a drug-induced psychosis. My response in that moment was an unintended, impulsive reaction against my better judgment to the discovery of Ray's romantic involvement with my wife. And for that, I'm sorry. I'm sorry that in that moment I was not mentally strong enough to control myself. I'm sorry that my horrendous action that day resulted in the undeserved deaths of Rayburn Barone and Anna Marie Abulaban. My partner, my best friend, the mother of my daughter, and the love of my life. I am ashamed of what took place. I am devastated by the damage that I've caused to Anna's family, to Ray's family, and to my family. If I could undo all of this, I wouldn't hesitate. If I could go back to that day, I would have left for LA first thing in the morning as I had originally planned. I would have given Anna the space she wanted, and I would have used that time to focus on getting the proper help I so desperately needed. And I would get on my knees and beg Anna for forgiveness. Forgiveness for becoming distracted, for letting my anxiety and my insecurities affect my thoughts and my behavior towards Anna and towards her friend. Forgiveness for using cocaine as a remedy and becoming addicted because of it. For neglecting my responsibilities to you, Anna, as your husband, and my responsibilities as a father. and for allowing the drugs to turn me into a pathetic empty shell of the man that she fell in love with. Because of those factors, I lost myself. And because of those factors, I lost Anna. I am so deeply sorry to each and every one of you who have suffered for the last 3 years. To the Cardenas Barron family, to Ray's mother and father, I am so sorry for what I've done to your son. To Jordana and his siblings, I am so sorry for what I've done to your brother. I really wish I could have gotten to know Ray the way that you all do, the way his friends did. And now, after seeing just how consistently you all showed up to this trial in support of him, I have no doubt in my mind that Ray was a good person. The world has truly suffered a great loss, and for that, I'm terribly sorry. I wish this never happened. To Anna Marie's family, whom I still love and consider to be my family, there's so much I want to say. To Anna's mother, Amalia, and to Ron, you trusted me to protect your daughter, and I failed you. I wish there was something more I could offer besides an apology. I wish there was a way for me to fix this. I'm so truly sorry for what I've done to Anna, her parents, her siblings, aunts, and her uncles. I feel terrible. Anna was the most beautiful woman I'd ever met, and I wanted to spend the rest of my life with her. To love and cherish her, never to hurt her, to build her up, not to break her down. But I failed. I am thankful, however, that Anna and I were able to have a child, a granddaughter for both of our families to rejoice with. It is my belief that the love and spirit that Anna radiated will continue on through her. To my beloved daughter. When you're old enough to see this, please don't blame yourself. None of this is your fault. Your mom loved you so much, and I love you so much. You are the strongest girl I've ever known, and I'm so proud to be your father. I'm sorry for what my foolish actions have costed you, from what's been taken from you. I'm sorry that now you not only have to grow up without your mother, but now you have to grow up without your father too. I'm ashamed. But that is why I will strive each and every day to better myself, to seek rehabilitation, and to hopefully one day come back home to you. Because not being a part of your daily life tears me apart. To the Honorable Judge Frazier, I want to thank you for being extremely fair to me throughout this trial and for giving me the opportunity to defend myself. It is truly unfortunate that despite the compelling evidence that this was a crime of passion, somehow the jury still landed on this verdict, and they certainly wasted no time in doing so. The fact that I spent more time on the stand than the jury took to deliberate my fate is very concerning. In fact, the jury foreman himself told Fox 5 news reporters that a few of the jurors wanted to pick second degree, but were pressured not to by the rest of the jury. I think that speaks for itself, loud and clear, that reasonable doubt was intentionally overlooked, and that justice was not the motivating factor behind the decision. It was vengeance. And now I am left with no other option but to spend the rest of my life in prison, death by incarceration, a very slow and drawn-out death sentence. That means in 50 years from now, should I still be alive, I would still not be considered for release. I don't think that's fair at all. Especially after it has been made clear that drugs and alcohol were involved. And add that to along with infidelity and mental illness, and you've got a recipe for disaster. One that anyone could fall into. It's happened to me and I still can't believe it. Being sent to prison without the hope of ever getting out honestly feels like I'm being sent to hell. And that's terrifying. And I don't think that's right either. Personally, I believe everyone should have the ability to parole because everyone has the ability to change. But nonetheless, even still, it is my goal to serve my time with the utmost outstanding conduct and to participate in every rehabilitative program while being a positive role model to other prisoners. And I will do all this to the best of my ability with the goal of one day safely transitioning back into society. And finally, to everyone else, I extend my deepest apology from the bottom of my heart. I'm sorry. I wish you all peace, healing, love, and abundant joy in the future. I will continue to pray that I may earn your forgiveness. Thank you.
You still believe there's still crime and passion, huh? You still believe that, huh?
In the end, the judge sentenced Abulabon to 2 consecutive terms of life in prison without the possibility of parole, plus an additional 50 years to life for firearm enhancements. Now we're in Pontotoc County, Oklahoma, where instead of a defendant losing their cool, this time it's an attorney. Rob B. Hopkins found himself on the wrong side of the law back in February. He was representing the mother of a child in a custody dispute. And from the start of the hearing, things were tense. As Hopkins tried to make his argument, he ended up in squabbles with both the judge and opposing counsel.
Okay, you pull out that pleading and you tell me what paragraph to go to. And again,
right here, affidavit of Julianne Kramer that was attached to her in support of special appearance and motion to dismiss. The education, the child has attended school, paragraph A, B, C, D, and E.
Of what?
Of her affidavit of Julianne Kramer, paragraph number 3, trial's residence. Since birth, that's OQW, has resided continuously and exclusively with
Judge,
me
objection, may I state my grounds?
Yes, sir, go ahead.
This is hearsay.
It's your affidavit,
Which
filed
is,
as part of this court.
Hush. Let him.
He's interrupted over and over,
Hush.
but you've not admonished him once.
Hush. Let him at least finish his thought.
I've not been able to finish one thought.
Hush. Finish your thought.
Your Honor, I appreciate that the affidavit is attached to pleading, but it remains hearsay nonetheless. I object on the basis that I can't cross-examine this. Well, it's not a witness, it's an empty chair.
I've pled, I don't know how long Mr. Palmer's practiced, I'm not familiar with him, but I'm sure longer than I have. And he's in a jurisdictional argument without a client present once or twice, I'm pretty sure.
Sir, you have no idea
No,
how
sir,
inexperienced I am.
Gentlemen, let me tell you my opinion. I am frustrated that your
I am too.
client is not here.
I am too.
Do not interrupt the court again.
Yes, ma'am.
I am frustrated that your client is not here. I am frustrated to know that there's an outstanding warrant for her, which might have something to do with her not being here. I don't know.
I wasn't done with my argument.
And I was not done with my statement. You interrupted again. Do not throw your...
I did not throw, it fell off the bench. Please stop stating things that are not true, ma'am.
Sir, you've got a room full of witnesses.
I do. I put it down. I did. I put it down and it fell down. I did not fall.
Then settle down.
I'm not upset and I'm not arguing. You're not letting me make an argument. I'm not red in the face, ma'am. I'm not.
Stop. Our court reporter cannot get what we're both saying.
This is as clear as the nose on my face that this woman will not appear before this court because she has a warrant for stealing.
Objection, hearsay. That's not true. And you're red in the face.
You will find, sir,
Don't
that you
put
cannot
me and
over me.
or shout at me.
I'm not putting down here. No, we're stopping.
Bailiffs approached Hopkins as the judge signaled she was holding him in contempt.
Get out of my face.
These people are my friends, and you're being ugly.
And get out of my face.
Yeah.
Why?
Because you're in direct contempt of court.
He shouted at me. No, I'm not being. You did not even say that I was in
You are
contempt.
in direct.
No, I'm not
Judge,
doing my
I
stuff.
apologize, but I felt very threatened by this person. The screaming and the yelling in court, I've never even heard that before in this courtroom.
At this point, Hopkins accuses the judge of targeting him because he's a transgender man. And from there, things went downhill very quickly.
Do not hurt me. Do not hurt me.
Put your hands behind your back.
Do not. Are you throwing me over the...
Stop resisting.
I'm not resisting.
Okay, put your hands behind your back, stop resisting.
You know exactly what's
Why
happening.
don't you all walk that way so you can...
I can't walk. I'm being thrown down.
Just settle down, walk that way.
No.
Settle down. Do not grab me. Do not grab me. What are you doing? What are you doing? What are you doing? You're hurting me. You're hurting me. You just take me. You don't take me. Don't get me. I can't breathe. I can't breathe. I can't breathe. I can't breathe.
Put your hands behind your
I
back.
cannot breathe. I can't breathe. I can't breathe. I can't breathe. I can't
Body camera footage from additional officers shows them hurrying to respond to the courtroom.
Get his other arm secured. I've got his legs. Put your hand.
Somebody call 911. Somebody call 911. Somebody call.
Let go of your phone now.
No. No.
Alright, we're gonna pick you up. Roll on your
No.
side.
No, I don't. Get a female officer now. Get a female officer now.
Get up.
Get a female officer now.
There aren't any. Get up.
I can't get up. I can't see. He just threw my glasses. I can't see. Give me my glasses. Put them on my face.
No.
Put them on my face. I cannot see.
Get up. Go.
Please give me my glasses. I cannot see. I'm trying to walk and I cannot see.
We'll walk you.
I need my wallet.
We will grab all your stuff. Come on.
I'm trying to walk. You're pulling me.
Walk.
Give me a chance. Give me a chance to walk.
Let's walk.
Thank you.
Let's walk.
I need him off me. I'll go with you. Get him off me.
Officer needed unknown or something.
Tell him we're 91. 16 Central. We're 91. We're in custody. I lost my body cam.
Unit, can you please repeat your badge number?
What's his name?
16 Central.
Him right there.
We're 91 with one in custody.
What's his last name? What's his last name? What's his last name? I don't need a substance. What's his last name? I got this here. What's his last name?
Yeah, what happened? They asked for assistance up there, so we went up there together. The judge said take him to jail for contempt of court. And then the fight was on. He's just trying to fix my body cam. What's his malfunction? Contempt. Arguing with Judge Jackson. She comes storming in the room. She said, go get him, take him to Justice Center.
So Hopkins was booked into jail, held on a $25,000 bond. Days after the courtroom chaos, Hopkins announced that his practice would be closing up shop And in April, the Oklahoma Bar Association suspended his law license. My gosh. Next up, we're in Michigan, where one of the nation's most prolific sexual offenders was sentenced to prison for his crimes against hundreds of young athletes. Lawrence Larry Nassar. He was the former team doctor for the women's national gymnastics team and a physician at Michigan State University. Turns out, he had been using his position to sexually assault hundreds of girls since the 90s. But he wasn't indicted until 2016. And over the next few years, he pleaded guilty to multiple charges in multiple courts. He would eventually receive sentences that totaled more than 100 years in prison. And as you can imagine, the depravity of his crimes meant that, tensions were running very high at his sentencing hearings, especially when brave young women came forward to talk about their experiences dealing with this doctor.
The news broke over the scandal that a girl who had Larry Nassar as her doctor reported sexual misconduct. My mind immediately thought about the time when I was 13, just a kid, laying on a table at MSU, and you put your ungloved hands all over my rear and slipped your thumb into the most private area of my body.
So then a man named Randall Margraves was in court that day too, and his 3 daughters all claimed they were assaulted by Larry Nassar, and he had a very hard time containing his anger.
Judge, would a distraught father have a chance to say something?
Go ahead, sir.
You.
No, we don't want to swear. We don't want to have profanity. I can't imagine the anger and the anxiety and the feeling of wanting retribution. And if you need to say something to help you, I'm more than willing to let you say something. But in a courtroom, we don't use profanity. But if you have some words that you would like to say, I would like to give you the opportunity to say
I would ask you to, as part of this sentencing, to grant me 5 minutes in a locked room with this demon.
I have
Would you do that?
That is not how
Yes or
our...
no?
No, sir, I can't.
Would you give
do
me
that.
1 minute?
You know that I can't do that. That's not how our legal system
Well,
works.
I want that son of a bitch behind your back. I don't. Give me 1 minute with that pastor. Go ahead. You're getting One minute.
Relax, sir. Relax. Take it easy, buddy. Just relax.
Yeah, so Margraves was led from the courtroom, detained in a holding cell, waiting for a contempt of court proceeding. He was brought back in to learn the consequences, if any, that he would face.
The court has to address the issue of a direct contempt involving one of the victim's parents, Mr. Randall Margraves. Sir, would you raise your right hand? I don't know what it would be like to stand there as a father and know that 3 of your girls were injured physically and emotionally by somebody sitting in a courtroom. I can't fathom that. Angie, the Attorney General, did share with me that you heard things today on the record that you didn't know before. I can see that absolutely creating an anger and a rage so great that any parent would want to do physical harm. So I understand that. But you have to understand that this is a courtroom. And this is where we carry out and enforce the rules of law. It is not acceptable that we combat assault with assault. There is no way that this court is going to issue any type of punishment given the circumstances of this case. And my heart does go out to you and your family because of what you've gone through.
Margraves did apologize to the judge and to the court for the disturbance. Now, for Larry Nassar, he'd been attacked at least twice in 2 different prisons and is currently serving his sentence out in Pennsylvania. Our next intense incident comes from a courtroom in Kentucky. The family of a murder victim lashed out at his alleged murderer during a preliminary hearing.
Yeah, I mean, they've got a few of the participants in that from that family or group in cuffs, and some of them are being arrested.
So it's September 2023, and Jalen Forrest is charged with murder and domestic violence in connection with the death of his stepfather, Victor Anderson Sr. Forrest reportedly strangled him to death. Days after his arrest, Forrest was in court for a preliminary hearing, and the judge started things off by warning everyone, as hard as it might be, she wanted a respectful courtroom.
This is a public courtroom, so everybody is welcome to sit here and to listen. I'm not going to allow any outbursts or discussions or conversing amongst anybody in the courtroom, and I do expect everybody to conduct themselves appropriately. You're on the record, and Jalen Forrest, Commonwealth versus Jalen Forrest.
The case detective took the stand to tell the judge what he saw at the crime scene, and almost immediately, things went haywire.
Detective Burns, were you involved in investigating a homicide that occurred on September 18th, 2023 at 4523 Broadleaf Drive?
I was.
Tell us how, not you personally, but how police were first called to that location.
So, on September 18th at approximately 3:41 in the afternoon, 2nd Division officers were dispatched to that address on a report of a male being assaulted. They had received that information from a 911 caller who had been on the phone with the victim when the assault was occurring. When they arrived on scene, they knocked on the door and heard a voice from inside say something to the effect of, "Hold on, hold on." They then made contact with a property manager or a
Hold on,
maintenance.
excuse me. Please don't let that happen again. You may continue.
Look back here.
Ma'am?
Judge, can we clear the courtroom?
Yes. No, just ma'am, I'm sorry. If you're not able to, you're excused. You can watch virtually, ma'am.
You're my handicapped daddy. And your dead ass daughter.
Ma'am.
You sick.
I don't know what I'm going to do.
Sir?
Can we clear the courtroom, please?
Step outside or I'm gonna hold you all in contempt.
He's got.
Go!
Yeah. He's got. He's got. Don't worry about it. I got somebody inside.
Oh.
He got me.
I have an issue with that. Yeah, that's a problem.
Ma'am.
That's a problem.
Do you want to join the rest of the folks who've left the courtroom?
You all good? Just hang out in here for a while. Yeah.
I'm gonna clear the courtroom. Everyone step outside for a second. I want the attorneys to approach. Everyone is excused at this time.
Sit down, do I leave? What do you want?
You're fine. Don't leave. Your presence is just excused until I'm able to discuss what to do next with the parties.
Even with the courtroom evacuated, yelling can still be heard outside, and the judge has to try to figure out where to go from here.
Yeah.
I mean, the other people that are not involved in any of that.
Hey, Mark.
Okay. The daughter they're
I
referring
have
to.
no inkling that any of that was going to happen, Your Honor.
No one's blaming you. The daughter they're referring to is his daughter who was.
When somebody said clear the courtroom, it was your motion to clear the courtroom.
Yes.
Just to be clear.
I thought you said it, so
I did do it.
Okay.
She did. But I
Yeah.
thought maybe I need, perhaps the court needs better training on how to address situations like that, because yeah, it probably wasn't safe.
I wasn't even looking, and I turned around and there was a chair
court judge
over my head.
Yeah,
I was trying to not
So
engage. And
it happened.
I just saw somebody with a chair.
Yes.
And
It
But the
happened
judge said
kind of out of
clear.
nowhere. I
You
mean,
do.
we have murder probable cause hearings most weeks,
Okay,
and
but judge
this
still
doesn't
said clear
always
the
happen.
They're fighting, and I don't want to go out there. I just want to keep.
Okay, you're good.
You're okay.
You're fine. You're fine. You're fine.
Will you, I don't even know what the protocol is, honestly. Like, I don't want to say anything and then somebody end up hurt because of it. I'm gonna.
I mean, I think that anyone who engaged in any threatening behavior is certainly can be excused from the courtroom and not allowed
I
to
don't
observe the
appreciate the
hearing.
threat on my client's life.
I did hear that.
I will say that
I didn't know.
he does have. There's somebody in custody right now who's accused of murdering his daughter.
Okay. So how would you all like to proceed?
I'll be ready to proceed in just a moment.
You want to go talk to him?
I need, Ms. Gilbert, perhaps you are aware, I know there's a rule. I can't kick everyone out of a public courtroom, but I think that I can.
I think that you can exclude certain
people,
out of this.
and I'm inclined to
Yes.
do that.
Yes.
Based on what I've seen.
Yes, I think that, I mean,
Every
normally would never say, Judge, don't let a victim's family
Never.
be in a courtroom.
But I think most of I can't say with any certainty that the entire group were all engaged in like threatening behavior, but most of them certainly were. So I'm not sure who wasn't part of that.
First responders tell the judge that multiple people are being taken into custody, so the judge decides she needs to close this hearing to the public.
Just calm down.
So I don't want anybody who I saw verbally expressive or outwardly physical to come back in.
Judge, I would prefer if no one comes back in. I think.
So it's your motion for a closed courtroom?
I think at some point, every single person over there said something.
It did seem like that.
Yeah.
I'm
After
ready.
the first person got removed, I think.
I think we can get started right now.
All hell broke loose.
What do you all think?
You can lock the door and do it without anybody.
Do you want to proceed now, Judge?
I'm going to have, this is going to be a closed proceeding, but I do want everyone to know that they can watch it on Zoom, because I don't think,
So you're not going to allow anybody back in the courtroom?
not the
is it?
families, no.
Because they're trying to clear out the hallway, but part of the problem is people are supposed to be in here, they're kind of hanging around.
People who don't have anything to do with the case can come back in.
Who don't have anything to do with the case?
Yeah.
Yes, ma'am.
According to Kentucky records, this case is still working its way through the court system. No outcome yet, but no word that there have been any more courtroom upsets. Next, we're going back to 2021, when courts, just like everyone else, had to shut down because of the COVID-19 pandemic. Most eventually set up these virtual proceedings to keep the wheels of justice turning, but look, had its own perils. For example, what do I mean? Defendant Nathaniel Saxton logged into a hearing in St. Joseph County, Michigan for his arraignment on a charge of possessing drug paraphernalia. Things go very wrong, basically from the first moment that he appears on screen because of his Zoom name.
Good morning, sir. What's your name?
Me?
Yeah, you. Yes.
Nathaniel Saxton, sir.
Your name's not 3000, you yo-ho. Logging into my court with that as your screen name.
Why
We'll
would that?
discuss that in a little bit. What kind of idiot logs into court like that? What's your name again?
Nathaniel Saxton, sir, but I don't believe that I typed anything like that in.
Well, that's what it says.
Why, I
discuss that in a
apologize.
bit.
That should not
Yeah,
be.
you should. I'll put you in the waiting room. You can sit in limbo for a while and think about what you call yourself online.
Yep, Nathaniel Saxton just logged into a public courtroom feed with an incredibly vulgar screen name. You can see on his face, though, he was absolutely dumbfounded by what Judge Jeffrey Middleton was saying. The exasperated judge booted him from the Zoom waiting room, and when Saxton came back a few minutes later, he had an explanation, kind of.
Your Honor.
Yes.
If I may explain, my sister was the one that set up my Zoom account or whatever. But is my iPhone pairing name for my Bluetooth speaker, sir. It's an inside joke. It's not what you think I'm I'm embarrassed. I'm sorry.
Well, you should be. All right, we'll come back to you in a bit.
That's embarrassing. When the judge finally circled back to Saxton, the prosecutor told the judge that Saxton had been found with a syringe that tested positive for meth. He pleaded guilty, was told to pay a $200 fine, and the judge also said that Saxton was very lucky he didn't smack him with a contempt of court charge. Next, we go to a Detroit courtroom where another defendant is appearing virtually, and straight away, there is a lot of confusion.
Good morning to you, sir.
Good morning.
What is your middle name? Can you remove your hat, please? And your scarf. What is your middle name, Mr. Garner?
Earl.
Earl?
No.
He's on the 130 docket, Your Honor, I believe.
James Garner. Earl Garner. James E-R-R-O-L Garner, right?
Yes.
You are on the 130 docket.
If you want, Your Honor, I can give House Counsel an offer right now. She can report it to him.
On James Garner, do you see all the cases he has?
I see just the 4 that are on the docket, or 5.
Yes.
He's got more?
He's got plenty more.
Okay. You want me to come down, review, and do a global offer?
If you could, please.
Okay, I'm on my way down.
Mr. Garner, do you want to offer on these or do you want to go to trial?
I would like to know what the charges are.
Okay. This is the city of Detroit versus James Earl Garner. Case number SP 11000435, counts 1, 2, and 3. SP 116950. Those are driving license expired, misdemeanor, no insurance, insurance misdemeanor. Thank you. And an improper plate misdemeanor. All of them punishable by maximum possible penalty of 93 days in jail and or $500 in fines. SP 1169507.
Yeah, that's a lot of charges and citations, and the judge slogs his way through them, but doesn't get much further after that.
Fines. Appearance for the record, please.
Sherika Harris on behalf of Mr. Garner. Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to state your name first. You got to state your name first.
No,
Let's start there.
Wait a minute, Ms. Harris. Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what? I mean, I'm confused about what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, city of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
Withdrawing my name from the record on that one. Thank you.
I know. How do you want to proceed, Mr. Garner? You set the matter. I'll enter a not guilty plea on his behalf. Give him a $0 bond. Either set the matter for trial or I'll wait for the city to give you an offer. What do you want to do?
Well, the court hasn't even established jurisdiction. I mean, in order for jurisdiction, the jurisdiction has to be established first, and there's no jurisdiction established. And once jurisdiction is challenged, that must be settled before charges can be brought.
All right. Do you want to put that in a motion, sir?
As far as I'm concerned, any and all charges must be dismissed because there is no complaining witness, and the state cannot be.
I'm not gonna listen. If that's your motion, I'm gonna deny the motion. Okay. So all we're gonna do now, we're not gonna keep going back and forth. Either you take an offer or you set the matter for trial. Which one do you want?
Respectfully, in order for this to continue, there must be a complaining witness, and the state cannot be a complaining witness. Now, if I'm entitled to a fair trial, the law states there must be a victim. I'm just requesting, who is the victim? Who did I injure?
The citizens of the city of Detroit and the state of Michigan are the victims.
The state cannot be a victim. And if that's the case,
I said the citizens of the city of Detroit and the state of Michigan are the victims.
If that's the case,
Mr. Garner, can we just go into a breakout room and then maybe I can give you a little bit of advice to assist you with moving forward? Would you be agreeable to that?
Sure.
Okay, awesome.
Garner comes back to the public Zoom meeting, but he's still uncooperative, and the judge has had enough.
I believe he's ready, Your Honor. He's representing himself.
Let's go back on the record with Garner. What do you want to do, Mr. Garner? Do you want a trial date or you want an offer? Those are really your only two options.
Okay, since we are on the record, all I'm asking for is the
Okay, one last time. Now listen, here's how it's gonna go from this point on. If you don't answer the question that I asked specifically, then I'm gonna hold you in contempt of court, and we're gonna move from that point on, right? Get up, Mr. Raymond.
So you're telling me,
Mr. Garner. We're not gonna have a conversation. Stop, sir. Stop, sir. Now, that's the last time I'm gonna ask you to.
On the law. Is that what I'm hearing?
All right.
I'm asking.
I'm gonna hold Mr. Garner in contempt of court. He is directly violating the court's order. I've asked him repeatedly to not interfere or add any extra commentary to this case. I've given him ample time to answer the court's question, and he continues to refuse to do so. So now I'm going to hold you in contempt, and I'm going to sentence you to 30 days Wayne County Jail. No early release.
So that means that the court is just going to violate my rights because I'm defending myself? Is that what I'm hearing?
30 days, Wayne County Jail, no early release.
The judge tells Garner he needs to report to jail immediately.
I have a question.
I'm not answering any more of your questions. Turn yourself into the Wayne County Jail today.
So the court is going to be in direct violation of my rights in the law. Is that where we're standing?
That's how you feel. Have a good day, sir.
Okay, now we're back in Judge Middleton's courtroom where a woman is representing herself on charges that she was arrested multiple times for resisting arrest. Rosalind Ray Keenan apparently considers herself a sovereign citizen. Essentially, it's a movement of people who believe the law doesn't apply to them, right? The Constitution was changed from its original form, and some sovereign citizens drive without a license, others may avoid paying their taxes, and many times they choose to go pro se, that they represent themselves in court. This case, it is immediately clear that Keenan plans to challenge just about everything that Judge Middleton has to say.
The title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris improprium persona, Rosalind Roslyn-Ray Colon, family of Keenan, comma, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Roslyn-Ray Colon.
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime I autograph is to be done in a certain manner that I have here, or it's forgery. Could you give this to the judge, please? That's mine. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan, beneficiary, with quick bail bonds.
The prosecuting attorney tells the judge he's been working closely with Keenan to try to work out something that everyone can agree on without any courtroom shenanigans. Not to be.
I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan.
He's offering to reduce the driving suspended charge, and he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim. I'm not gonna tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm gonna have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the?
It's a benefit. And
No, before that, about the license.
He's dismissing it, and it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it, and that's a benefit. He is offering to reduce the felony charge to a misdemeanor, and that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's
Explain
just
it.
put
I'm
on
not
a
playing
prelim.
games. I'm serious.
You are playing games, and first of all, you
I'm
don't.
trying to advance to
All right,
what I'm
stop.
here
You
for.
don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do you want me to appoint an attorney for you, or would you like to represent yourself?
So may I ask what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case.
So Keenan is out of her depth in representing herself and reads some of the information she's found online about the court's jurisdiction or lack thereof. But the judge corrects her and reminds her she's being offered a pretty good deal, and that is when things go downhill from there.
Record of the court show that this is a criminal action. And my next question is, I know that the Constitution grants the court two types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these two jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. And I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed. And I would like it in writing, please.
Thank you. It's not civil procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting. for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct.
I'm competent and I am confident. Okay?
All right.
So
the next question is, are you willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to appear for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All
under
right, stop.
admiralty or military tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's
procedure.
the Sixth Amendment grants me the right to know the jurisdiction being applied.
And I told you what it was.
And it gives you the duty.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, please.
Please.
We're going to talk about this tomorrow at 3 o'clock. I find that you're in contempt. You're going to jail right now, and we will. Well, you have been.
I'm simply
this matter
trying
is
to
adjourned
exercise
until tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. And you will be more respectful to the court.
I can provide the
You will not interrupt
citation.
the court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can go
If you wanna
with the
continue-
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We will address this tomorrow at 3 o'clock.
Stand up and put your hand.
No.
I can't get her aspects because they're.
They'll get them for you. You can give all the paperwork to him.
Thank you.
Mr. Marvin, I don't know what you've got tomorrow at 3 o'clock, and I don't know what I have, but we'll take another shot at this tomorrow.
Justice takes time.
Just misunderstood.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
Yeah, so Keenan has to spend the night in jail on a contempt charge. Her son was also in the courtroom and seems to want to help his mother through her legal troubles.
That's it, then this court over.
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that. But,
Well, I told her to stop and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's going to contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock. And to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admiralty law.
please have that record still, or that chart, that option still, if I talk to Mr. Marvin.
Yeah, I guess so. Well, you can't represent her as a lawyer.
I know.
But he could, yeah, Mr. Marvin wants this to be over with.
I do too.
All right.
Thank you.
Next day, Keenan back in front of Judge Middleton, and things go very differently this time.
Ms. Keenan had previously indicated she did not wish to have an attorney, and there was no attorney on her behalf at that time. Prosecutor David Marvin was here yesterday, and there was one or more police officers that were here yesterday prepared to testify. We didn't get very far. we started to go through the particulars, but Mr. Marvin made a plea offer. I want to repeat that, Ms. Keenan.
Prosecuting attorney wasn't able to be in the courtroom, but the offer he made the day before still stands.
He stopped in this morning and confirmed to me that his plea offer was still open to dismiss the felony charge and the driving suspended charge for the plea to attempting to resist or obstruct a police officer. We were talking with Ms. Keenan yesterday. I found that she was in contempt and ordered that she go to jail, and she did, and we're here today. We were trying to establish whether she wanted any legal assistance in this matter. So, Ms. Keenan, you're the same person that you were yesterday with the same reservations and concerns. Is that correct?
Thank you. I have some things, like proof that the license shouldn't have been suspended, and they did reinstate them in Indiana.
All right. Well, he's willing to dismiss that charge.
I think that's why, because I showed it to him.
All right. Well, maybe so. He said you and he had several discussions. So let's see if we can get to square one here. Do you want an attorney to assist you in this matter? I can appoint one and we can set it for further hearing. I don't want to force one on you, but I do think you could benefit from having counsel. It was clear you didn't understand the difference between a criminal case and a civil case, and you contempted yourself into a day in jail. I won't be offended if you tell me that you want to have an attorney, in which case I would set this matter for further proceeding out 2 weeks.
So if I choose to get an attorney, I have 2 weeks, and then nothing else will be brought up today.
Correct. Now, you could enter the plea to the misdemeanor offer that Mr. Marvin made today. But I do think you could benefit from having an attorney to assist you with this, in which case I would continue it to the 5th of July. That's 2 weeks from today in the afternoon. Usually it'd be on a Tuesday, but that's a holiday. It would be 1 o'clock on July 5th.
Am I going to be still having to stay at the county jail and wait till?
Well, let's talk about that. No, you posted a $10,000 cash or surety bond. However, you've not agreed to be fingerprinted. So as soon as you agree to be fingerprinted, you can be released from jail. Otherwise, you're going to sit there for 2 weeks. All right. Would you like me to appoint an attorney for you?
Yes, if you appoint an attorney,
Go
they're
ahead.
defense attorneys.
Yes.
Okay.
Here's your son. All right, I'm going to appoint an attorney, which I think you could benefit from. I guess you can always say later, I don't want one, but it looks like you have an opportunity to consult with one.
Thank you.
But you're not to be released until you complied with the booking process, including photo and fingerprints.
Excuse me.
Yes, sir.
Today,
Yes,
I think it was today, or maybe because I slept a lot, so I don't even. Anyway, they booked me and took my picture.
all right, well, the
Is that
picture's
good
done.
enough?
That's good enough, but you
That's
have to
good
agree to
enough?
the fingerprints.
Oh, I still have to do the
Yes.
fingerprints?
And you can decide whether you want to do it. If you don't, that's
Well,
up to
I'm
you.
going to do it.
All right.
Because I appreciate your offer. Thank you.
Seems Keenan learned her lesson, at least this time around. Now, we can't do an episode about big courtroom moments without talking about one of the defendants on the Mount Rushmore of wild trials. I am, of course, talking about Darrell Brooks, the man eventually convicted of driving his SUV into a Christmas parade in Waukesha, Wisconsin. He killed 6 people, wounded dozens of others. And when it came to his trial on intentional homicide charges, Brooks decided his only option was to represent himself.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot. That's putting it minimal. A lot. So I have not had the time to go through everything that's in there. I'm winging it, Your Honor.
Day 3 of the trial, there was a cordial moment between Brooks and Judge Jennifer Darrow when Brooks apologized for any of his antics so far.
I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, you know, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way.
Understandably so. This is an emotional experience, I think, for everyone involved. And I appreciate that you, upon reflection, have realized that courtesy and decorum are an important part of a court proceeding.
Yeah, but that didn't last very long. His lack of understanding of everything from courtroom procedure to the law, he disrupted the proceedings again and again.
Should be properly addressed before the jury even comes out. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you asked me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work.
Brooks often argued the jury wasn't being given all of the information they needed to make a decision, but Judge Darrow wasn't having it.
That's not fair to the jury. They have a right to hear everything. I'm not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, there ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are
please,
being
nothing.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present
and
in this courtroom.
under what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law.
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law, you
ruling.
can't do that.
I need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom.
Judge Darrow removed Brooks to a separate courtroom several times during the course of this trial so he wouldn't interrupt the proceedings, but she could still monitor what was going on.
Am I muted?
No.
The jury should know that they can nullify.
You are muted now.
Yeah, there were times that Brooks removed his shirt. He also built a fort out of evidence boxes. He would wave his arms so he could be seen on camera, but refused to wear the headphones so he could hear what was going on. And when he was allowed back in the courtroom, he continued to disrespectfully challenge the judge.
All right, the jury's coming back out, and I'm going to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom.
I object to
Did
that,
you
Your Honor.
hear what I said, sir?
No, I did not. I object to that, Your Honor.
That
And it
I've
doesn't
cited
say
previously.
anything
I'll
that-
make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said.
none
Your
of that
Honor.
is required, sir.
Because it
And
is. You can't verify
your
any proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks.
And despite his efforts to defend himself, Darrell Brooks was convicted on all 76 charges, including 6 counts of first-degree intentional homicide. The jury deliberated for only a few hours before reaching that decision, by the way, and Judge Darrow sentenced Brooks to 6 life sentences plus 700 years.
You know, in addition, and before I get to that, I've also had, over my 11 years on the bench, of coming face to face with evil on occasion. There are many times, good people do bad things, but there are times when evil people do bad things. There is no medication or treatment for a heart that is bent on evil. Child trauma, bipolar, indifference, physical abuse of a child, or even childhood trauma did not cause Darrell Brooks to commit the acts for which he will be sentenced here today. It is very clear to this court that he understands the difference between right and wrong, and that he simply chooses to ignore his conscience. He is fueled by anger and rage. Some people, unfortunately, choose a path of evil, and I think, Mr. Brooks, you are one of those such persons. As a mom, my heart breaks for your family, for your mom, and for your grandmother. The son that she raised, the grandson that your grandmother knew, the hopes and dreams they had for your life, they're gone. And I think it's perhaps far easier for them to blame a mental illness than to perhaps come to grips with their son did very, very bad things due to very bad motivations.
That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. See you next time, everybody.